Well, hello there. This is Wade Emmert. Welcome to the update for HIPAA for the first quarter of 2026. Before we get started, let me introduce myself. I am a board certified health law attorney. I'm a partner at Carrington Coleman, and I am board certified. I am certified by the International Association of Privacy Professionals, both as a certified information privacy professional and as an artificial intelligence governance professional. So this is right up my alley. I'm excited to talk to you today about everything that's happened in HIPAA over the past several months. So without further ado, let's turn our attention to HIPAA. So over the past several months, we've seen significant developments in healthcare privacy and the healthcare security landscape. From proposed major overhauls to the security rule to enforcement update actions to the rise of artificial intelligence in healthcare creating new compliance challenges. Today, we're going to cover the most important developments you need to know about for this first quarter of 2026. I'll go over the key stories and the regulatory changes from the latter part of 2025 through March of 2026. So here's what we're going to cover today. First, we'll look at the proposed HIPAA Security Rule, which is the first major update in over 2 decades. And then we'll discuss the deadline for updating the notices of privacy practices. Pro tip, you've missed it. It was in February last month. We'll explore how artificial intelligence is creating new compliance challenges. We'll talk about recent enforcement actions and updated penalty structures. We'll examine the scale of data breaches and vendor risks. We'll cover important legal and legislative developments, and we'll wrap up with some takeaways and action items for your organizations. All right, let's start with the biggest unknown in HIPAA right now, the proposed overhaul of the security rule. This is the first significant update since the rule was originally published, and it represents a fundamental shift in how the government expects healthcare organizations to approach cybersecurity. So why is this happening now? Well, you just need to look at the numbers to understand why. Healthcare has been the #1 targeted industry for cyber attacks for 13 consecutive years. The existing security rule simply hasn't kept pace with modern threats. When we talk about the security rule, we're talking about the rule that requires certain IT security controls. There's also a privacy rule that deals more with policies of the healthcare provider, but the security rule is designed to keep the information safe from unauthorized third parties. In 2024, healthcare data breaches affected more than 182 million individuals. Actions which were, of those individuals, that was something like 670 different incidents. That number is probably actually a lot higher with the ransomware with Change Healthcare impacting millions more. So the proposed update was published in December of 2024 to be finalized in May of 2026, with the rule likely becoming effective in July or August of 2026. Now, you may think that this gives the healthcare organizations some runway, but not quite as much as you might think. So here are the key proposed requirements. First, and most significantly, there's a distinction between required and addressable implementations in the old rule. That distinction is being eliminated. People used to think that required was a security control that an organization was required to implement, and addressable was something they could address if they chose to or if the situation warranted. Well, now that distinction is going away. Organizations can no longer treat addressable items as optional. Everything becomes mandatory. So all electronic protected health information must be encrypted. That's another requirement, both at rest and in transit. Multi-factor authentication will be required on all systems that offer access to electronic PHI. When an employee departs, their system access must be terminated within 24 hours. If a cyber incident occurs, organizations must be able to restore lost systems within 72 hours. And organizations will need to conduct annual compliance audits, maintain technology asset inventories, and perform network mapping. Manual compliance approaches using spreadsheets and human-led audits will no longer meet those standards. This is a big issue for many healthcare providers. If they are using an electronic health record where the vendor is not meeting these requirements and does not understand their obligations under the new security rule, that can put healthcare providers at risk for violating the security rule. The industry response to this proposed rule has been somewhat divided. On one side, you have CHIME, which is the College of Healthcare Information Management Executives, CHIME, and more than 100 hospital systems have called for HHS to withdraw the proposed rule entirely. In a December 2025 letter to HHS, they cited what they called crushing regulatory burdens and requested that a more collaborative approach be implemented to design a new rule. On the other side, the Office of Civil Rights, which is the governmental agency that's targeted or tasked with implementing the HIPAA rule or levying fines for violations of the HIPAA rules, they've defended the proposal, arguing that cybersecurity attacks cost organizations far more than compliance would, both in reputational damage, ransomware payments, system remediation, civil lawsuits, and regulatory penalties. Even the industry groups that oppose the updated rule acknowledge that cybersecurity is a patient safety issue. The rule's future remains uncertain under the current administration's deregulation agenda, but experts recommend that organizations start adopting best practices like the NIST cybersecurity framework now rather than waiting for a mandate. All right, in January 2026, the Office of Civil Rights issued new guidance that establishes system hardening and patching as mandatory components of the HIPAA Security Rule. Now, this is separate from the proposed security rule update. They mandated hardening and patching as mandatory components of complying with the current security rule. Regulated industries or entities must maintain IT asset inventories, monitor vulnerability alerts from NIST and from CISA. CISA is the Cybersecurity and Infrastructure Security Agency. Conduct vulnerability scanning and implement formal vulnerability management programs. Patching outdated software must be treated as a continuous process than an episodic task. When patches aren't available, like for legacy systems or zero-day vulnerabilities appear, OCR requires alternative security controls be implemented, such as network segmentation and access restrictions. If these terms don't mean anything to you, then you need to find somebody that does understand these terms. These are industry type standard types of security controls that many organizations already implement in other contexts. Certainly, this can be done for healthcare organizations. And then finally, organizations must document testing and evaluation of system changes through their HIPAA risk analysis process. All right, our next major topic is the deadline to update your Notice of Privacy Practices. This was one of the most widely covered HIPAA stories in recent months, and for good reason. The deadline for compliance was February 16 of this year, and it requires action from virtually every HIPAA-covered entity. Unfortunately, HHS has not issued an updated model notice, so organizations are going to have to work with their attorneys to draft appropriate language. So what exactly is required to change? What needed changes are there in your Notice of Privacy Practices? Well, the primary driver is the alignment of HIPAA standards with 42 CFR Part 2. People just call it Part 2. These are the regulations that govern substance abuse disorder records, or SUD records, substance abuse disorder. HHS published this rule in February of 2024 to be effective February 16th of 2026. Under this new framework, patients can grant blanket consent for use of their SUD records for treatment, payment, and healthcare operations. The old requirement was that they had to give separate consent for each disclosure. So even though blanket disclosures are now, blanket consents are now appropriate, SUD records still carry heightened confidentiality protections. For example, they cannot be used in legal proceedings without patient consent or a court order. Your notice of privacy practices must also disclose these restrictions, provide opt-out options for fundraising, and include redisclosure warnings. Critically, this doesn't just apply to SUD treatment providers. Any HIPAA-covered entity that receives Part 2 records must update their notice. So when updating your notice, remember that HIPAA establishes a floor, not a ceiling. States can and do enact more stringent requirements. New York, for example, now implements or imposes a 30-day breach notification deadline and has expanded its definition of protected health data to include medical history and health insurance identifiers. Colorado prohibits disclosing patient information for out-of-state investigations of gender-affirming or reproductive health care. Montana and Nevada require faster patient access to records than HIPAA's 30-day standard. New Mexico's requirements requires patient consents for electronic record disclosures, and Alabama recently raised its age of medical consent from 14 to 16. Your updated notice of privacy practices must reflect these state law requirements in the states in which you operate. The point is that organizations that fail to analyze and incorporate state laws risk noncompliance with both federal and state law requirements. All right, now let's turn to one of the most rapidly evolving areas of HIPAA compliance, the intersection of artificial intelligence and healthcare privacy. Obviously, artificial intelligence is transforming the healthcare industry and healthcare delivery, but it's also creating entirely new categories of compliance risk. HHS has proposed expanding HIPAA Security Rule requirements to explicitly cover AI systems that handle patient healthcare data. The January 2025 proposed rule, scheduled for finalization in May of 2026, establishes that if you are going to use PHI in AI training data, predictive models, and algorithms, your organization is going to have to jump through some hoops. Organizations will need to maintain written inventories of AI software and monitor for vulnerabilities. Critically, public server tools like ChatGPT do not comply with HIPAA privacy and security rules. AI tools must use encrypted internal servers. Civil penalties can reach $50,000 per violation, or criminal penalties for knowing violations range from 1 to 10 years imprisonment, with fines between $50,000 and $250,000. Additionally, 12 states have already enacted their own AI healthcare legislation. So this is a multi-layered compliance challenge. Now, if you're looking at some of these numbers and thinking, well, $50,000 is a lot, but I can weather that storm. It's $50,000 per violation. Every patient record that is disclosed is at least one violation. And so if you have 500 patient records that are disclosed, that is potentially 500 different violations, each of which has a $50,000 potential fine. All right, so let's look at two concrete examples of AI risk in practice. The AI medical scribing market is booming, from $397 million in 2025 to a projected $3 billion in 2033. But 13 states require all party consent for recordings, meaning you can't just use an ambient recorder to record conversations without the patient's consent and without their knowledge, both the patient's consent and the provider's consent. So first, AI Scribes. In November of 2025, a class action lawsuit was filed against Sharp Healthcare, alleging that they used Abridge's ambient AI documentation tool to record over 100,000 clinical encounters without patient consents, violating California's all-party consent wiretapping statute. The lawsuit claims that Sharp's EHR, electronic health record, notes contained fabricated consent language, claiming that patients had consented to recording when no such consent had been given. Obviously, a problem. Second, de-identification risks. A de-identification is the process of removing or obscuring protected health information from medical records so that the data cannot be linked back to a specific individual. This enables the use of health data for research, analytics, and public health purposes while protecting and preserving patient privacy. The problem is that researchers at NYU demonstrated that AI language models can re-identify patients from medical notes that have been stripped of all these HIPAA identifiers. Their model achieved over a 99.7% accuracy for predicting the biological sex and produced re-identification risks 37 times higher than the baseline. This is significant because there's a multi-million-dollar market for de-identified clinical notes. The researchers argue that we need to shift our analysis from legal consequences or to legal consequences rather than just focusing on the technical solutions for de-identification. AI changes those technical solutions. We need to look at consequences, the consequence of selling information that can be re-identified. All right, let's move to enforcement now. OCR has been busy and the penalties are getting larger. Enforcement has returned to pre-pandemic levels, and in some areas is even more aggressive than before. So let's look at some specifics. OCR levied more than $6.6 million in HIPAA fines in 2025. Here are 5 notable settlements. Syracuse Ambulatory Surgical Center paid $250,000 following a ransomware incident where they had never even conducted a risk analysis and also failed to timely notify nearly 25,000 affected individuals. How many of your providers, or how many of you who are providers, have ever done a risk assessment or a risk analysis, sometimes called a gap analysis? If you haven't, you're putting yourself at additional risk, not only for the ransomware attack to occur in the first place, but also for large penalties to be imposed after the fact. Another settlement, Deer Oaks paid $225,000 after a coding error exposed patient information online for 18 months, followed by a network breach affecting over 171,000 individuals. Cadea Healthcare paid $182,000 for posting patient names, photographs, and treatment information as success stories without written authorization. And there are other examples of this type of these settlements with OCR. Additionally, a $200,000 penalty was leveled against an academic medical center in March of last year for right of access delays. This was OCR's 53rd or more enforcement action on patient access. Notably, the proposed rule updates may reduce the response time required from 30 days to just 15 days, meaning if a patient appropriately asks for access to their records, failing to provide access is called information blocking. And so that timeline for organizations to respond may be decreased from 30 days to just 15 days. Another area of focus of OCR settlements. All right, the penalty structure for HIPAA violations was updated effective January 28th, 2026, under the Federal Civil Penalties Inflation Adjustment Act. Here are the updated tiered structure. For unintentional violations, penalties range from $127 to nearly $64,000 per violation, with an annual cap of about 1.9 million. Now remember, it's per violation. So if you disclose wrongfully 500 records, that is potentially 500 different violations. You can see how these penalties can increase very, very quickly. And that's just for unintentional violations. The most serious category, willful neglect, not corrected within 30 days, now range from $73,000 to over $2.1 million per violation, with an annual cap of $2.1 million. So if you willfully neglect and then don't correct even a single violation, you could find yourself in the millions of dollars of penalties. There's also criminal penalties. Criminal penalties can reach $250,000 per violation and include 1 to 10 years imprisonment. Interestingly, penalties for Part 2, substance abuse disorder violations, are actually lower than HIPAA penalties, despite covering more sensitive information. There is a 2019 Notice of Enforcement Discretion out there that remains in effect that lowers the maximum penalties in 3 of these 4 tiers, but organizations should not rely on this notice. It remaining it's not certain, and it's not going to be in place indefinitely. Finally, let's look at the alarming scale of healthcare data breaches and the growing risks from third-party vendors and business associates. The numbers are pretty scary. And they underscore why regulatory changes are being proposed. So healthcare data breaches affected 289 million individuals in 2024. This in large part was because of the Change Healthcare ransomware attack in 2024. But even that aside, in the first part of 2025, over 31 million individuals were impacted. And again, that's just the first half of 2025. A survey of 613 healthcare professionals found that 60% of organizations have never or have experienced a HIPAA-related incident or a near miss. So most healthcare organizations have either violated HIPAA or nearly violated HIPAA, certainly as it relates to data breaches. Of this number, 49% of those incidents were caused by internal employee error, not external hackers. So a very significant component of a potential HIPAA breach, data breach, is caused internally by your own employees, likely because of inadequate training. Business associate agreements, we all know what those are. When a vendor has access to PHI, they sign a business associate agreement, ostensibly imposing upon them certain requirements to keep that information safe. But business associate agreements don't absolve providers of responsibility when a breach occurs at the vendor level. Connected medical devices and cloud-based applications often integrate third-party software that may not meet the same security standards. So just because you have a vendor doesn't mean you are off the hook. Just because you have a business associate agreement doesn't mean you are off the hook. And you need to be thinking about what software you are using. I know of healthcare providers that use Google Docs or Dropbox. Those are not HIPAA compliant, at least not in their standard commercial configurations. Those types of tools are not compliant, and you are at risk if you are using those types of services with protected health information. Another significant risk is online tracking pixels. Now, this was big for the past several years. I think it's dying down a little bit, but the numbers are still pretty staggering. Tracking pixels are embedded in websites, and it tracks patient or website visitors' navigation through different pages of your website. And if some of those tracking pixels is on a page that contains protected health information, or sometimes on the page before that leads you to that page with PHI, that can inadvertently reveal protected health information to unauthorized third parties. These platforms have already, people have used these types of pixel tracking services for patient portals or telehealth platforms, have already incurred over $100 million in fines for this unauthorized data sharing and sharing it to analytics and social media companies. One of the biggest tracking pixels is the Facebook, now called the Meta Tracking Pixel, but other companies have these as well. Organizations need to conduct a thorough vendor risk assessment. They need to make sure they do have business associate agreements that cover them. They need to make sure that their vendors are actually following these standards. They need to make sure that internally their employees are following appropriate HIPAA guidelines and HIPAA practices and not using software that's not HIPAA compliant. All right, a few more emerging risks to be aware of. First, legacy PHI and email systems is a ticking time bomb. During business email compromises, a handful of compromised emails can contain PHI for tens of thousands of individuals. Spreadsheets that your financial person emails to the CEO of the healthcare organization, that's protected health information. Or medical records sent internally from provider to provider for consults or for overreads. Though that type of information is obviously protected health information. Internal emails typically contain the most PHI, but often fall outside of encryption requirements, meaning it's internal and people don't use encryption to protect them while they are at risk or in transit internally. Organizations should implement archiving. They should use encryption for all PHI shared by email and deploy email filters to detect PHI before it's transmitted. Second is the issue of offshoring patient data. HIPAA doesn't actually prohibit offshoring or accessing PHI outside the United States, but covered entities remain fully liable for breaches by offshore vendors. And regulators face real limitations in pursuing offshore entities, so they're going to come after you. Several states, however, do go further. Texas prohibits offshore data work. Ohio bars offshore contracting for state agencies. And Florida prohibits certain providers from sharing or storing records outside the U.S., its territories, or Canada. Finally, OCR has established a new enforcement priority around parental portal access. Parents must now receive electronic access to their children's non-confidential health records through patient portals. Many organizations had blocked all parental access for adolescents due to technical limitations. They'll now need to reconfigure those systems to separately provide access to separate confidential information from routine care. All right, several significant developments, legal and legislative developments to note. A Texas lawsuit challenging HIPAA was dismissed in November of 2025. The Texas Attorney General had challenged not just the 2024 reproductive health rule, but also the validity of the entire 2000 HIPAA privacy rule itself. The case was dismissed by joint stipulation, which was a significant outcome for HIPAA's continued authority, though questions remain about about future state challenges after the Supreme Court's order or ruling in the Loper-Bright matter. On the legislative front, the proposed HIPAA Information Privacy Reform Act, or HIPRA, which would extend HIPAA-style privacy, security, and breach obligations to entities currently outside of traditional covered entities. In other words, outside of the application of HIPAA, this would be like wearable companies, healthcare apps, wellness programs, retail clinics, perhaps, and data vendors, certain data vendors. HHS initiated information blocking enforcement back up to HIPAA. That's on, right now there is no federal law which protects the privacy of those wellness of your data in certain apps and other healthcare organizations outside of HIPAA. Some states are starting to fill in those gaps. If HIPAA is to pass, that would be a significant step forward from a federal level, but state laws are still very much involved and are stepping in to fill the gaps. HHS has initiated information blocking enforcement in September 2005 under the 21st Century Cures Act with penalties up to $1 million per violation. No actions have been taken yet, but the infrastructure is in place. And HHS is undergoing reorganization, reducing its workforce from 82,000 to 62,000 employees, and creating a new assistant secretary for enforcement. So the impact on regulatory pace and enforcement capacity remains to be seen, but there is initiatives to become more to increase enforcement actions for these types of violations. All right, let me leave you with 6 key action items. First, update your notice of privacy practices immediately if you haven't already. The February 16, 2026 deadline has already passed, and it required you to update or address Part 2 substance use disorder requirements. You'll need to also check state-specific mandates as well. Second, start preparing for Security Rule update, the Security Rule 2.0. Even if the rule's future is uncertain, begin your gap analysis now. Encrypt all your PHI right now. There's no reason not to. Implement multi-factor authentication, inventory your technology assets, and establish a 27-hour system recovery capability. That's something you should have anyway, regardless of the security update. Third, audit your AI tools. Inventory every AI system that touches patient data. Ensure that they use encrypted internal servers and establish proper consent protocols, especially for AI scribes. This is not just the AI tools you know about, but also the AI tools your employees are undoubtedly using in their job. If they are using ChatGPT or Claude, unbeknownst to you with patient information, PHI, you need to know about that and take steps to prevent that. Fourth, strengthen your vendor oversight. Conduct annual vendor risk assessments. Customize your business associate agreements to address AI-driven analytics and behavioral tracking, and implement continuous monitoring. Fifth, address email and legacy risks. Archive old emails, encrypt all PHI in transit, use email filters to detect PHI, and review your data retention policies. And then 6, stay ahead of enforcement by conducting thorough, documented risks analysis. The single most common finding in OCR enforcement actions is the failure to complete a comprehensive risk analysis. If you do a risk analysis and identify certain gaps in your security and take some meaningful steps to close those gaps, OCR will look favorably on you if you do have a data breach. You need to take steps to understand where you are weak and to take steps to strengthen those weaknesses. Thank you for joining me today. I appreciate your interest in HIPAA and the recent developments in HIPAA. The next live event that I'll be doing is June 22nd. It's a survey of state patient privacy laws as they apply to healthcare providers. All right, until next time, I thank you for your time today, and I look forward to seeing you in the future. Take care.